Good afternoon, friends. I extend a very warm and hearty welcome to all the participants and learned speaker to the 79th webinar on bizarre business barriers, impact of new Benami law, anti-money laundering law, and black money law on our personal and business life ahead. Being organized by corporate profession as a part of its knowledge sharing initiative, which we have started last year on 28th April 2021, and then continuously we are doing this exercise. There is an extensive legal, regulatory and administrative framework in India to curb the problem of illicit money. The primary law, the Prevention of Money Laundering Law, provides for rigorous imprisonment and also fine for money laundering crime. The Benami Law empowers the authorities to provisionally attach properties and confiscate the same if the property is adjudicated Benami. The Black Money Law prescribes very stringent penal consequences. Added to this, that is a interplay of these laws with the Companies Act, FERA, FEMA, Companies Act, and other economic laws, and the stringent KYC norm laid down by various regulators, including RBI, SEBI, and IRDAI. During the course of business, sometimes certain transactions are done, wherein knowingly or unknowingly some omission are done. And resultantly, these transactions are heaped under these laws, which are very draconian, leading to various harsh actions such as attachment of property, arrest, etc. Therefore, while doing business, we need to take care of our part as also to take care of Bonafide of the person with whom we are doing business. Keeping in view the importance of subject and the repeated request received from some of our participants, we are hosting this webinar, being fourth in the series on this subject. The expert to deal with the subject are very well known authorities who have been on both the sides as regulator as well as the practicing advocate representing clients. I'm sure the participant will make full use of their presence by forwarding their questions. We have already received various questions, and in case you have any question, you can give it to us. Now I will introduce our learned speakers for this program. First, we have Dr. R.N. Das. He is a former Indian Revenue Services 1976 batch and worked till 2012. He retired as Director General of International Taxation for India. While in service, he worked both in the policy and also in implementation area of tax laws. He worked in the tax policy division of the Department of Revenue during 1990. He was appointed as member judge in the Appellate Tribunal under the Prevention of Money Laundering Act 2002 from 2012 to 2016. From 2012 to 2016. He was the acting chairman of tribunal when he quits the job. He has the experience of working for international organizations like UNO and African Development Bank as consultant. He has a doctorate degree in business administration, a degree in law, and double master's degree. He is active as an advocate in Delhi, Mumbai, and Bhubaneswar. His work's area of focus in economic and financial law. We welcome you, sir, and definitely you have designed the law, you have given various judgment, you have created this particular environment in India through the legal jurisprudence, and now you are on the other side and you have experience. Your experience will definitely benefit to the audience today. Welcome you, sir. Then we have Mr. Ashwini Taneja, is a former member of Income Tax Appellate Tribunal. He is a CA, CS, and ICW and fellow member of Indian Council of Arbitration. He has also done his LLM. He practiced as a chartered accountant from 95 to 2007, and between 2007 to 15, he practices as a lawyer with RRA Tax India. In 2015, he was appointed as member of ITAT and was posted at Mumbai bench, where he delivered more than 2,000 judgments covering wide variety of issues in a very short period. In 2017, he resigned as a member ITAT and again joined legal profession and now practicing as lawyer with RRA Legal, specializing in the area of income tax and Benami Law. He is a prolific speaker and has delivered lectures and participated in debates on different top forums, including TV channel, on various issues of income tax, Benami Law, PMLA. Number of landmark cases argued by him before different courts or authored by him at ITAT have been published in the leading tax journal of the country. So Ashwini sir has a chartered accountant experience, then he has a lawyer's experience, and then he has a regulatory side experience. He has delivered various lecture, various decision also. So he understands both the sides problem. And today we will understand his point of view relating to this law and how to prepare. Our third speaker is Mr. Amit Khemka, who has been practicing as a litigation lawyer in Supreme Court, High Court, and other courts of the country, and has handled large number of cases involving complex issues, some of which have made headlines in the country. He also regularly participated in debate of All India Radio and various TV channels and delivers lectures at different forums. He is appearing in various cases of PMLA, Benami Law, and the black money, and now slowly he is expertising in the economic law area. So I welcome you, sir, for this program, and your deliberation and your expertise will definitely benefit to the speaker, all the participants and the fellow speakers. Friends, today's webinar we are structured in such a manner that after my introduction, I will request Dr. Das to say, then Ashwini Taneja will give his presentation, and then we have a question answer session, and in that Dr. Das, Ashwini Taneja, and Mr. Amit Khemka will give answer of your queries. I have received few queries, but you have any question, please write to us. So friends, now you can understand that this particular law is Vijar law we are talking, these all laws. And why? Because there are certain points are missing here and certain point is harsh. Yesterday I was reading newspaper in Kitish Zambaram case where Tushar Mehta was arguing, and they were saying that this law itself is a complete, we don't bother to see other laws, whether CRPC, CPC, and whatever it is. And then the issue is that whenever there is a law, that law cannot be complete in itself. You have to harmonize the intention of our constitution and other laws also, and then you give a judgment. But yesterday when I was reading newspaper, I was shocked that they are saying this law is complete, there's no need to refer other things. And I will request Dr. Das, when he will discuss that this issue, he will must throw some light that is it so tough that you can't see anything, you can't harmonize with other things, and whatever mentioned in this law is complete. Because in so many places, if you read section 3, section 4, section 45, and various other sections, you will find that it is not completeness and it's giving non-clarity also and the issues. And they are taking advantage, because I remember when the section 45 declared unconstitutional by the Supreme Court on certain aspects, then some relief people got in the system. So we will definitely see this, that what our learned speaker will speak on this. So now I will request Dr. Das to start his initial discussion and suggest us. And my request to all participants, any query you have, please send it to us. I have received few queries, but you can send it to us. We will take care and we'll ask from the learned speaker. Over to you, Dr. Das. Sir, you have to unmute yourself.
Thank you so much.
Yeah.
Thank you, Pawan ji, Ashwini ji, Khemka ji, friends. It's a pleasure, as usual, to be with all of you this afternoon. It's a vast subject. However, I'll try to deal with it with some initial remark, and I'll confine myself to PMLA, that is anti-money laundering law. You see, we started our PMLA law because of international obligation to combat the global menace of laundering illicit funds. That led to Prevention of Money Laundering Act 2002, which was effective from 2005. The act gave expression to India's commitment to United Nations to enact a domestic legislation, because we are a signatory, we participated to curb the laundering of money linked to drug trafficking and similar serious crimes. Please note, drug trafficking and similar serious crimes. Therefore, the scheme of the act before any amendment was made to it, unamended act, evinced unequivocal intention of the Indian legislature to crack down on proceeds of a crime arising out of scheduled offences specified under the act at that point of time. However, later on, a series of amendments have sought to systematically dilute the original intent of the act, reducing it to an instrument of arbitrary power in the hands of its implementer, that is ED, and its masters, to poke their nose into the all kinds of crimes. Right? This is first. Second, I must point out the implementation has flaws because it is an opaque kind of investigation.
I think there seems to be some power failure.
Yeah. Ashwini sir, till the time sir is coming, can you...
Or we can invite Khemka sir if he is available.
Khemka sir?
To...
Till the time Task sir is joining, share your thought.
Initiate the dialogue and we can take it forward from there for a few minutes, because Khemka sir was busy in a meeting. I requested him to join at a shorter request because his views are thought-provoking and brings a lot of clarity in our mind.
Good evening, everyone. Good evening, Pavanji. Good evening, Ashwini-ji. And good evening to all the participants. The subject for today, not only it is important, but one thing I noticed was it was very rhyming also. Bizarre, business, so it was very rhyming, kind of a poetic thing. So that is what we expect from Pavanji, that whenever he does in a very poetic and artistic way. Anyways, but nonetheless, these laws have no poetry in it. These laws are as harsh as, as the complex as they can be. And to my mind, what makes them complex is more than what they want to achieve, more than the punishment or more than the penalty. What makes them strange and harsh is the vagueness in the law. I'm very sure Ashwini-ji will explain to you in greater details. When a law is made, law should be very, very specific. Law should be very, very clear. If they wanted to make a law which is retrospective, they should have said so. What was the harm? In all these economic laws, there are cases pending in the Supreme Court where they have virtually, Supreme Court and different high courts, where the question of retrospectivity is pending. बात करो उनको जाके. So I am saying that whatever penalty is there, fine. The legislature wanted to have it. We will debate whether that penalty is harsh or whether that penalty is proportionate or not. But the question is, if due to vagueness, you are giving a handle for corruption in the hands of the people, then in the hands of the officers, that creates a problem for the business community. Almost every one of these laws, if you see, have many questions which are yet to be answered. And that is why even Supreme Court is hearing for last almost about 3 months in relation to PMLA, various almost about 50 odd questions have been had to be drawn. And the Supreme Court is hearing various counsels on that. So I feel that the vagueness which could have been avoided by the legislature could have been very, very clear as to what it wanted to do. Now, because of that vagueness, because of ad hocism in legislation, the major problems have arisen. Now, Das sir has come, so I will just hand over the baton back to Das sir. I was just, sir, filling the gap, and although it was जिसे कहते हैं ना धृष्टता थी मेरे पार्ट पे कि मैं आपका I was trying to fill the gap, but फिर भी sir, whatever I could, please continue, sir. Please continue.
Thank you very much, Kamkaji. I'm extremely sorry. My apologies because of the power outage. I was disconnected for a while. What I was telling about the clause in PMLA, I was dwelling on the opaque system of investigation, because in police investigates on the basis of FIR, it is supervised by the courts. They have to submit case diary. There is a system in existence. But ED does it. They file an ECIR, which is counterpart of FIR, in absolute secrecy. They do not share it with anybody. You can get a copy of FIR, but never a copy of ECIR. What is in it? What I can say from my personal knowledge, the ECIR is a mechanical document, copy paste of certain parts of FIR. That means no independent investigation has not been done by the ED to ensure that it is really there is a proceeds of a crime and there has been effort to launder it. Money laundering crime emanates from this thing. So, and as I said, it is opaque because it is not. Nobody is supervising it. There is that is only internal. Then the number of searches they do, there are manifold searches, surveys, and all these things. So they are really threatening.
Can I just add something to the issue of you said about the ECIR copy?
Yes.
Can I just add something, sir?
Yes, please.
Sir, first of all, the CRPC was made with completely in mind that whatever case is triggered, whatever investigation is triggered, there should be a control over that investigation. It should not be unbridled. That is why CRPC mandates that the copy of the FIR within 24 hours has to be sent to the Ilaka magistrate, and anybody can inspect it there. Anybody can get a copy of that FIR from there. Similarly, in PMLA, there is a provision that a copy of the ECIR has to go to the adjudicating authority. So it is the intention of the legislature remains absolutely clear that you are not supposed to do an unbridled investigation or uncontrolled investigation. That is first. Now, what is if it has gone to the adjudicating authority? What is the harm in giving a copy also? What was argued by the learned Additional Solicitor General before the Supreme Court few days ago, or maybe day before yesterday, that it will take away the secrecy or the confidentiality of the investigation. Now you are going ahead with an investigation against a particular person, and you don't want even the grounds on the basis of which you have initiated the investigation, because ECIR must contain enough grounds at least for initiation of investigation. So prima facie case must be there. If that prima facie case is not there as to how you have started the investigation, and you are shy of sharing that with the person concerned against whom you have started the investigation, he has the right to challenge it. He can say that you had no grounds to initiate the investigation itself. So I feel that there is a bonus. There is a bonus being given to the officers by this kind of arguments, that they can take the law in their own hands. They can do something which is arbitrary in nature, and this is not the law. This should not be the law. Thank you, sir. You can go ahead to the next point.
You have articulated it appropriately well. But you in our since it is a secret, we are thinking it is probably a treasure, that ECIR. But actually, it is a very hollow document. Where the few I could see, I have seen that it is an inept attempt and mechanical attempt, and they probably want to hide their inefficiency. So I think so. Now going to the another aspect, you see, in 2012 and 2019, they made certain amendments whereby they told PMLA stands on its own legs, separate from predicate offense. See, I am not dealing, since it is introductory and I am not dealing with it at length. You see, how can there be fruit without the tree? And if you want to launder money, you need that there is a proceeds of a crime, and that crime, you are saying, even if that crime does not exist, this can exist, laundering can exist. It is why this amendment has been done. This amendment has been done to give the legislative burial to investigative ineffectiveness of the ED, so that they don't have to do anything about the other things. They simply जो भी मन को आया तैयार कर देते हैं, वो वही हो जाता है. See, 17-18 section 17-18 में जो amendment किए 2019 में, and those have really they thought that this will stand on its own legs, but it cannot be. You cannot separate money laundering offense from predicate offense. This is also a fundamental error that has crept in, and it has changed the structure, the entire body of the money laundering law. Then I'll now come to what Pawanji was mentioning about Tushar Mehta's wisdom flowing in the courtroom, that this small book of money laundering law is a complete code in itself. I would consider it as an arrogant assertion on the part of the learned lawyer, because it has been, it is claimed all along also. It has been claimed before me also. Then also हम लोग इनको point out करते थे. You see, section 4 and section 65 clearly says that there is CRPC is involved. And moreover, you cannot have a complete code. The jurisprudence is such a vast ocean without taking the benefits of the legal principles, legal decisions in all other laws, you cannot probably deal with it. And basically that this issue itself needs to be discussed at length. But what I wanted to tell you, this is also another way the law as it stood, they have tried to make an aberration, and it is untrue. It is not really proper. Then no judicial checks and balance on investigation is possible. That is that I have dealt with when dealing with CIR, comparing with FIR. Then conditions of a bail have been made very stringent and unnecessarily so. Norms for arrest, you will see, while for attaching the property, the requirement is reason to believe that property is involved in money laundering. But norms for arrest requires higher level of reasoning. That is, you have to say that he has committed money laundering. That reason to believe have to be given. But it is done perfunctorily. Only, whatever there in the provisions of the law, in the arrest warrant, same thing is written. And the reasons to believe is not shared at that stage with anybody. It has to be shared with adjudicating authority, God knows for why. So the thing is that all these things have made this law what you call draconian. It was not meant to be draconian when it was originally done. The people, the select committee people, the people involved in its drafting are getting amazed, wondering what it has become now. And they're not really happy. And it is unfortunate that the legislature, when they passed these amendments, they were really not alive to the impact of the amendment on the core purpose of this law. You see, this law is required to do something really good for our economic system. But unfortunately, because of these flaws, it has created a little bit of a small monster has come out of it. And as Khemkaji was saying, Supreme Court is dealing with it for months, and the people are wasting so much of time because people wanted to do something easily, and that is why they have changed the law. You see, it is like changing the rules of the game while the game is on. It is something like that is happening. So with this, and I am not dwelling on any other law at the moment, with this, my initial remarks I am closing. Thank you so much.
Thank you very much, sir. You have really giving a right direction. I was just wondering, as a student, when I read this law first time, that was the law that for you have to do for the drug trafficking and other thing, which has converted to the violation of a small technical violation of SEBI and company law. It has converted. So the point is, and you are also right, that that was not the intention of the legislator. But now, if you see the list of scheduled offense, you'll find each and everything. That is one part. Second is, I am finding every day in the newspaper, whatever crime you are doing, ED is coming in the picture. So it is whatever crime is happening, the crime is connected with the ED. So that is another point, and which what Amit Khemkaji has mentioned, the vagueness of law is a very serious thing, and that has to be cleared. Now, in my opinion, this law has become the tool of arm twisting that is not good for the business and not good for the entire country's jurisprudence. I hope Ashwini Taneja ji, with his experience, what he's facing, And then Amit Khemkaji will also share his experience of some cases which they are finding that this law is bizarre. And this law is really in such a manner that the basic principles are not followed and the clarity is not there. And then misuse of the clarity. If something is not clear, then misuse is bound to happen. Over to Ashwini sir.
Thank you, Pawanji, for inviting me and organizing a webinar on such an interesting topic, which is need of the hour for not only every businessman, for every citizen of the country. And thank you, Das sir, for setting the things in motion, and Khemka sir for bringing out certain crucial aspects. I want to do a small experiment today before I begin my deliberations here. Wherever you are sitting, please just have a look around and see the things which you are having, the building in which you are sitting, the table or the chair which you are using, the things are lying around you, the clothes which you are wearing, or the spectacles you are using. Whether any of these would have been available here had somebody was not in business. Suppose we remove business from our life, what kind of life it would be around us? Nullity.
Not business, business or professor.
Yes, of course, sir. I am, yeah, of course. I mean, there are certain things I'm now speaking in a very, very generic sense. So anybody who is in business or profession or any similar occupation, unless he is into that, I don't think we'll be able to live our life. So even life cannot be imagined. So there cannot be any better explanation for the utility. So now a businessman who is bringing life into existence, proper existence. I mean, can we presume that each one of them is culprit? Of course not. Everybody will say, of course not. Not only businessmen, other than businessmen, people will also say, of course not. Now, under these peculiar circumstances, on the other hand, the need of the hour for the government is to govern, to regulate the economy. But probably in the zeal, we forget one thing very important, that what is meant for what? Whether the law is meant for us or we are meant for law. We just reverse the things. How and why? The law is here to make our life easier, regulated, smooth, organized, and not just the reverse of it. So probably in the zeal, in the over enthusiasm, I don't know for what reasons, probably these things have been forgotten. That any harsher actions or any harsher law is like surgeon's tool. And it has to be used like a surgeon's tool, like a surgeon uses his tool while performing surgery. And if he uses that sword, I mean, the massacre is bound to happen. So, I don't know how and why this, these things happened like that in our country. So I will request for sharing the slide before I can begin my deliberations. Yes, I have got the right to.
Yeah, you have a right. You can.
Yes. So this name, bizarre business barriers, it came to our mind when we saw many people who are really aiming to do good business, but struggling to come out of the litigation, unwanted litigation, unplanned litigation, undesired litigation, most of the times not for a mistake, not for a deliberate mistake done by them. Even if there was a mistake, it was most of the times not a deliberate one. So that is how the businessman is facing a barrier to do business. We used to talk about ease of doing business. We used to talk about a support mechanism coming from the government. But all that vanished and these barriers and obstacles came on our way. So hats off to those businessmen, though, I mean, despite all these infrastructural issues, they are able to somehow take care of these obstacles and sail through. So I have never heard any businessman winning award for this. But if anybody in the country deserves any award, it is a businessman. Maybe there may be some wrongdoers, but they are the people who are creating wealth, who are creating a platform of employment. So how can we ignore this? Merely because he is working for profit. He is working for a profit because he can survive and he can provide wealth. He can create wealth, if for himself, then for the country also. And who is not working for a profit? A salaried class is also working for his own gain, own livelihood. Anybody and everybody is working for his profit, his gain. So whether to work for gain or profit is a crime. I really do not understand how these things got blurred. And we started blaming a businessman in a generalized and presumptuous manner. That is where the mistake has occurred probably. And while framing the law also, this kind of mindset is reflected the way provisions are created. The way reverse burden of proof kind of provisions have been created. The way they are giving this kind of explanations that why should we give ECIR? Why should not you? You are charging a person. You will tell him why you are charging a person. Is this a document of national security? That it is a document of national security. Why you simply copy down everything from FIR, something which is a public document, and you do not want to give him so that he is not able to meet the defense. So he is not able to meet the defense, meaning thereby, without granting him in the legal rights, you want to hit him. So you want to hit him illegally. Because legally, if you will proceed, you will not be able to hit him. Is that your thought? I mean, what is your thought? Our constitution is not based on this kind of concept. So, I mean, a time has come when our government needs to evaluate the net impact of the economic offences laws on the business entities. Net, after all, the laws are meant for us, not vice versa. So if laws are meant for us, we have to see whether these laws are going to give us the benefit, or the net result is that it is going to take away everything from us and we will be helpless, not in a position to carry on our business. I mean, this recent report, I hope you must have come across this organization who has carried out research, Team Lease, RegTech and ORF, that, I mean, people have been jailed for doing business. And the report says there are over 26,000 ways an entrepreneur can land in jail for non-compliance of business laws. I'm not saying that you should not jail somebody who is a wrongdoer. But I'm saying that you should ensure while preparing the law that law is not prone to misuse. And you should also ensure that no person is rendered remediless. I mean, Jungle Raj and a civilized society mein yahi farak hai. That in a civilized society, the things are absolutely organized. Before you take an action before anybody, you have to ensure that if an action is done wrongly, then there is a remedial mechanism for that. And remedial mechanism is working as smooth and effective as the action-taking mechanism is working. But here the vice versa has happened. Action-taking mechanism is in full force. Investigation agencies are in full force, full swing. But appellate mechanism is missing. The appellate tribunal of PMLA Benami is not working, not functional. I mean, since Honorable Justice Manmohan has retired, it is, I mean, in the public news. So how can you even allow your officers to pass an order if the appellate authority is not working? How? You don't have any sensitivity towards the citizens of this country. This photo, and you know what the main problem is more than this is that the canvas of these laws has become so big and so vast that it is difficult to imagine that, I mean, which kind of law out of these as a bolt from blue will come over your head and hit you hard. You can't even, I mean, imagine, even if you are doing the things in the most rightful manner. So, I mean, this small picture, you must have also come across it, you must have seen it in the newspaper, that 2 chimpanzees were attached by enforcement directed under PMLA. I also thought that how come chimpanzees can be attached by ED? What business they have? It is the business of the forest authorities. So the logic which is given something like that is that there was forgery of some certificate, then there was violation of Environment Protection Act, so Wildlife Protection Act. So these both the laws find place in the schedule appended to the PMLA. So they are called scheduled offenses, and anything derived, any proceeds derived from commission of a scheduled offense is proceeds of crime, and proceeds of crime is liable to be attached under section 5 of PMLA by the Enforcement Directorate. So that is how attachment was done, but thankfully they were handed over to the zoo authorities for their proper upkeep. Then this news also you must have read, that Modi's Benami Law has companies running for cover. And I mean, all across the country, there are many companies who have been seriously hit under the Benami Law. So what to say of politicians? Now the businessmen, all the companies, including the listed companies, they have been targeted. Infrastructure companies, land banking owning companies. I mean, they have been doing transactions which were allowed, which were structured, welcome. Companies Act allowed them. The structuring was allowed under the Companies Act. But now they have been put under the scanner of doubts and suspicions and allegations and all that. And people are suffering, I mean, knowingly or unknowingly. CBI ED actions may now follow IT default probes. Now, these 2 investigation agencies, I mean, will be working, rather all 3 of them will be working, and one other we can add to it is SFIO, Serious Fraud Investigation Office, and we can also add SEBI to that. So these agencies will be working in tandem, in close coordination with each of them. And so multi-layered actions are possible, multiple actions are possible, double jeopardy is also possible. Whatever comes to your mind, all of it is possible. And the memorandum of understanding are being entered into between the various agencies. Particularly CBDT is in the process of entering into various MOUs with different investigation agencies such as SEBI, such as ED, such as other departments, etc. So as I said, the main issue which we are facing today is that any one transaction you do, you have to evaluate and examine it from various angles, from the angles of various laws which might be applicable knowingly or unknowingly. So new findings which is of the investigation agencies is that most common ingredient found in the violation of laws related to economic offenses is that transactions done are Benami in nature. Because what do we mean by Benami? Benami is something which you see where the real ownership is hidden, where the real picture is concealed, and only the ostensible or the registered owner is shown. So if a person would be doing any transaction illegally, so he would be doing it in pseudonym or opaque manner, non-transparent manner, disguised manner, etc. So therefore, there are chances that the elements of Benami would enter into it. And now the specific legislation has been created to deal with and prohibit such kind of transactions and make confiscation of any such property. And also, I mean, very serious other consequences like prosecution, arrest, fine, etc. So let us begin with understanding of this Benami only from the perspective of a businessman. So, sir, this theme, entire topic has been created by Pawan Bhai, keeping in view the specific needs of a businessman who is in the regular course of business engaged into doing of many transactions. So knowingly, unknowingly, he should not be stuck doing in transaction that he comes into the radar of investigation agencies without any invitation or without any intention to do anything illegal. So we will have the basic understanding of these laws Sir, I am discussing these laws not from the point of view that you are going to commit a mistake yourself, so you should be aware of this law. Yes, you would say, no, sir, we don't want to do anything wrong. We are going very clean. No, sir, not from this point of view. I am saying from the point of view of the mistakes done by the other persons, and you enter into a transaction with him and then you suffer. For example, when you do driving on the road, you're driving your car. So you don't take care of your mistakes mainly. You take care of the mistakes with the other drivers, other people coming across, crossing the road or coming in front of you or from behind of you. They can hit your car, they can do anything hanky-panky, create a, chaotic situation. You have to take care of those things more than focusing on your driving skill. So similarly, while doing transaction, now the time has come when we as a businessman should enter into only those transactions which is clear and far from being hit by any of these agencies. So therefore, this basic awareness becomes essential, that how I shall ensure that the transaction which I am going to do is clean and not prone to be hit under these laws, apparently at least. So let us begin our understanding with this Benami itself. So friends, this Benami is based on the thing when a transaction or a property or thing is being shown in a manner where the reality is something else. So with regard to the ownership of a property, when the ownership is divided into two parts, then Benami law comes into picture. Meaning thereby, suppose a property should be owned by a single person, but if the ownership is divided into two parts, part A, that is owner is a person who is a registered owner, ostensible owner, and another owner who is not the registered owner, but who is the real owner, who is actually having the control he is having control and dominion over the property, and is also having the control on its usage and its fruits and all that. So he can be termed as beneficial owner, and the person who is only a registered owner can be termed as Benamidar, as they have been described under the law, new law with regard to Benami transactions. So for example, on this graphical presentation, you would see that there is a person B who is a seller of an asset, who wanted to sell the asset to Mr. A, and Mr. A wanted to buy the property, and he pays for the sale consideration also. But instead of getting the sale deed executed in his name, Mr. A suggests Mr. B to execute the sale deed in the name of Mr. C. And Mr. A and Mr. C has their tacit arrangement that Mr. C shall keep the property in his name, but for the benefit of Mr. A. So real control will remain with Mr. A, and Mr. C will remain the registered or the ostensible owner. And the entire consideration is also paid by Mr. A. So if both the conditions are fulfilled, two conditions are fulfilled, the property becomes Benami. And the new law addresses Mr. C as Benamidar and Mr. A as beneficial owner. So, but the only thing to be kept in mind is that both the conditions should be fulfilled. If only one condition is being fulfilled, if only one condition is getting attracted, if both elements are not available, then it will not be Benami. Both have to be simultaneously, conjunctively fulfilled. Only then it will be Benami. So there could be many reasons why Benami transactions has been done by the people since few decades and rather few centuries, I would say, because there were certain laws which prohibited ceiling or which brought out a ceiling on the amount of land holding, and which also brought out some prohibitions with regard to holding and transfer of properties from one community to the other or one class to the other, etc. So there were some land reform laws. So violation of these laws, apparently complying with these laws, but in true sense, violation of these laws led to introduction of Benami law. Then tax evasion. Of course, to evade tax, transaction will be done some other way. So that was the reasons people did Benami transaction. That is how law has been brought out. Converting black money into white, etc., etc. Fraud on creditors like bankers, financial institutions, etc., and many other corrupt practices like Prevention of Corruption Act mentions of such corrupt practices like bribery and all that. So what kind of transactions can be treated as Benami? In fact, the the law has brought out a specific definition, and the definition clause is so wide and so wild that anything which can be possibly Benami on this earth has been covered, very beautifully covered, smartly covered in the definition of Benami transactions, which is given under section 2 bracket 9 bracket A or bracket B or bracket C or bracket D. So 4 parts are there of section 2.9. Part A is the classic case which we just discussed, that property transferred or held by Benamidar and consideration paid by beneficial owner, and the property is held for the beneficial owner's benefits. Then we have property held in any fictitious name. So if any property is held in the name of any god or goddess, then the property may be straight away treated as Benami, or in the name of any person who is not a legal person recognized under the law, any natural person. Suppose he is not in the nature of natural person, then it will be in the name of fictitious name. Then it is automatically, by invoking clause B itself, it will be Benami. No, nothing, no exceptions, no ifs and buts, nothing required to be proved. It is spontaneously, automatically, ipso facto Benami. Then part C, where the owner is not aware of the ownership, denies the situation of ownership, denies the factum of being a title holder of the property, then that kind of property has also straight away treated as Benami, such as, suppose such action takes place and in the course of such, the ladies of the house denies any awareness, knowledge, and denies any ownership of the shares, any shareholding, any partnership, any other asset, then that leads to invoking the clause C. And if it is proved that the owner is not aware about the ownership of the asset, then it is treated as Benami, and consequences are quite harsh. And then D, pair of consideration. Pair of consideration is not traceable or is fictitious. This clause is being misused by the department this is clause D, by hitting those cases where the additions could not be made under section 68 or 69. So those transactions are being roped in here. We need to challenge the constitutionality of this law here, because even in a case where a person is not fictitious, he is identifiable person, but merely because he is not appearing, he may be treated as non-traceable before the officer, and officer can invoke D. So this invoking of this section becomes quite harsh in such circumstances. Now, there are no exceptions to these A, B, C, D, except 5 exceptions which are given to part A only. No exceptions have been given to part B, C, and D. So only for part A, exceptions have been given. And exceptions are in the name of Karta or member of HUF, they can transfer to each other. Then Benami will not be applicable. Then person acting in fiduciary capacity. Suppose a person is acting in fiduciary capacity, if any property is transferred in his name, then it will not be treated as Benami. Say, in the case of a director, partner, trustee, etc. Property purchased in the name of spouse or in the name of any child. It should be his or her spouse only, not anybody else's spouse. So property purchased in the name of spouse or child, or in the name of brother, sister, linear descendant and descendant, or where the part only cases are there, the exceptions have been given. But the condition is that the amount should be paid out of known sources. Suppose a person does bribery, earns income from bribery, and that amount he uses in buying property in the name of spouse, then the benefit of exception will not be there. So it has to be from known sources. So it does not mention about legal sources, does not mention about declared sources, does not mention about tax paid sources. So it mentions about known sources. So I wonder, Dasar and Khimka sir, suppose a person says, yes, from bribery he has purchased the property in the name of spouse, can he get the benefit because it is known, or any other thing which remains untaxed? So whether the benefit will be given, these are the questions which are left unanswered here. Second important thing, if property is being purchased in the name of mother, father, grandparents, grandchildren, brother or sister, then the person buying such property needs to be joint owner. If he simply buys in the name of brother or sister and he is not the owner, then this benefit will not be available. So in that case, 2 conditions are required to be fulfilled. If a person wants to buy property in the name of, say, his mother, then A, he should be making the payment out of known sources, And B, he should also be joint owner in the property in the registered conveyance deed. Only then the benefit of exception will be given. The last exception is for power of attorney cases. So property is transferred on power of attorney to someone, full consideration received. But there are two conditions to it. And both these conditions are required to be fulfilled and very difficult to be fulfilled. First condition is that adequate consideration should be paid. And so first condition is that stamp duty, the contract giving the power of attorney should be registered, and stamp duty applicable thereon should have been paid. So if both the conditions are fulfilled, I think it will most likely the conveyance deed would be entered. So in power of attorney cases, these conditions are not necessarily fulfilled. So what will happen to the power of attorney cases? I mean, strictly speaking, as per law, they are prone to be hit under this law. Then these are broadly the authorities. The enforcement responsibility has been given to the income tax department only. And I mean, a unit in the Benami prohibition unit has been carved out, and so enforcement is being done by the income tax officers only, who are specifically deputed under the Benami prohibition unit, and the enforcement officer is called here as initiating officer, who initiates under section 24, launches the proceedings under section 24 and takes it forward, and then makes attachment of the Benami proceedings, and then also Benami property, and then also files reference before the adjudicating authority if he finds it Benami, and then also files prosecution with the help of DI if he finds that the person is liable for prosecution also. So then the third is adjudicating authority, as I said. So if matter is over from the initiating officer, then it reaches to the adjudicating authority. Earlier there was pan-India jurisdiction with the adjudicating authority located at Delhi, but now 4 authorities have been created all over India. One is at Delhi, other is Mumbai, then Kolkata and Chennai. And after the adjudicating authority passes the order, aggrieved party can take the matter to the appellate tribunal. It is not the income tax appellate tribunal, it is the appellate tribunal, which is actually appellate tribunal of SAFEMA, COFIPOSA, PMLA, NDPS, FEMA, and then under Benami also. So these are the broad categorization of the agencies. Then let us also evaluate the impact of new Benami law. Few fundamental questions are arising in our mind, such as whether the transaction done in past but the properties continue to be held presently can also be attached under the new Benami law, whether there is any future time limit for making attachment of the property purchased today under this law, whether properties acquired in the names of close relatives can also be attached as Benami, for example, in the name of brother, sister, mother, father, grandparents, grandchildren, wives, brother, sister, etc. What about the property acquired in the name of wife? What kind of properties are covered under new PVPT Act? Whether immovable properties only are covered or movable also covered? Whether it affects any particular class of people or any individual of any class can also be roped in? Whether the bona fide intention and bona fide motive of a person can be an escape route or legal defense, and whether such transaction can be excluded from the proceedings under PVPT Act 1988? Is there any protection to the purchaser who had no knowledge of Benami transaction, who is a bona fide purchaser? Whether any protection is available to a bona fide purchaser under the new law? Whether the provisions of PVPT Act debar the provisions of Benami law and vice versa? Is there any scope of U-turn if Benami transaction is done inadvertently? Is there any provision of compounding or settlement under the law? Whether the application of other laws is debarred if the provisions of PVPT Act are applicable? Is there any payment and provision of payment, any compensation from the government to the affected party for the wrong attachment done by the department? So I would say that these questions, when you read, you imagine an answer to it. But surprisingly and shockingly, when you will know the correct answer, it might be just reverse of which you are thinking. Now, with regard to retrospective operation, you would be thinking that how can this be applied retrospectively? How can the new liabilities be created, whether criminal or civil or whatever? But the fact is, the way this law has been created, it attempts to cover all transactions also, even done prior to 1/11/2016. Because section 1(3), which was commencement section, which says the provisions will get into effect from May 1988 and September 1988, that has not been altered. So therefore, there has been chaos in the country, and IOs all over the country are hitting all the transactions, even the oldest transactions also. Though matter reached before few high courts, like Niharika Jain matter in the case of from Rajasthan High Court, like Ganesh Deelcom from Kolkata High Court, and Chhattisgarh High Court also intervened. But these High Court said these are prospective, but this matter was taken up, matter was taken to Supreme Court by the department, and the Supreme Court has stayed the effect of the order of Kolkata High Court, which is declaring that the provisions are prospective only. So therefore, because that the operation has been stayed, the IUOs are continuing to treat the old transaction also as Benami. Then no future time limit is there. Most surprising thing here is that with respect to any legislation, you will find there is some time limit, but here there is no time limit, my dear friends. I mean, law does not talk about any time limits. So if a transaction is done today, I mean, it is quite possible that in future times to come also, by doing the transactions, as suppose the transaction is given, the transaction is done today, then what could be that? What should be the time limit? Whether the time limit should be 1 month, 2 months, 3 months, a decade, or 2 decades, or even lifetime, or even after the lifetime of a person, the attachment or the actions can be brought out. With due respect, but I am suggesting that though if any wrongdoing has been done, it should of course be taken to task. But our constitution has also attached great sanctity to the concept of finality of the litigation. Our constitution states that the sword of litigation should not kept be hanging on the heads of the businessman, or on the heads of the citizen, or on the heads of the government also, if government is a litigating party. So some finality should be there. That is what is a theory principle followed in any civilized society, but here probably it has been omitted to be done. So I do not know what is the rationale behind it. So some time limit should have been fixed here. Now, as far as property is concerned, it covers not only immovable property like land and building, but also movable and other assets. For example, shares, FDRs, bank accounts, gold, etc. So the widest possible definition has been given of the property. I mean, you imagine any property, whether movable, immovable, anything under movable also, any rights therein also, they all are covered. Any class, it may not hit only rich, but poor also, as it has no threshold limit. It may affect not only urban people, but rural also. Any profile, it is troubling not only errant politicians, but also officers in the public service or otherwise, businessmen, employees of PSUs, as well as private sectors, and every else who may possess wealth in the form of properties not found registered in their names. And rightly so. Any structure. It is roping in corporate as well as non-corporate entities and individuals as well. So when the Benami law was brought out, it was imagined as if it will hit only the errant politicians, because for businessmen there are many other laws already available. But today it is hitting corporate more. Only hardly few politicians have been roped in so far. And it is hitting the corporate class and hitting those transactions which have been allowed so far. So that is what is happening today. And any intention, whether there was any malified intention of the offender or not, if a transaction has been done, which is being treated as Benami, then the property held as Benami allegedly may be attached and then finally confiscated under this law. So even if unknowingly some transaction has happened, or there was no illegal attention, no malified intention, still the attachment, there is no provision which saves from attachment and other actions under this. Yes, under section 53, circumstances having been given for prosecution, but that itself is so wide that a person will be covered in one of the clauses. Then with regard to bona fide purchasers, now with regard to bona fide purchasers, though protection has been given, but the way law has been drafted, the protection is inadequate, vague, because there are two conditions which have been given under section 27 of PBPT Act that says that suppose somebody has purchased a property which is being attached as Benami, First of all, if the property is being purchased after issuance of notice under section 24, and even if it is not in the knowledge of the purchaser and he buys the property, then the property may be attached. That is problem number one. Problem number two, it says if the property is purchased before issuance of section 24, then under section 27, benefit may be claimed provided two conditions are fulfilled. Condition number one, that adequate consideration should be paid and the person buying the property should have no knowledge. Now, both the conditions are very difficult because who will prove it is adequate consideration or not? And who will prove whether the person had no knowledge of the Benami transaction or not? Though we argued one matter before Honorable Justice Manmohan and he has held in the case of PMLA Bhardwaj, the burden is upon the IU. But the issue arises that with regard to knowledge, how it shall be proved. So therefore, here I want to give a word of precaution to the people, the businessmen who are going to do transactions, that suppose you are dealing with Mr. X for buying a property, and suppose the property is registered in the name of Mr. Y, then you have to be extra careful lest Mr. Y is Benamidar, which will be, revealed from his profile, the capacity to pay, etc., etc. Then the Benami law makes no distinction between black money and tax paid money. Any property held Benami shall be treated as Benami under the law, and all consequences of its confiscation and prosecution of offender shall follow, irrespective of the fact whether the tax paid money was used, untaxed money was used, whatever money was used. If the transaction is Benami, it will be treated as Benami, and consequences of attachment and other consequences of prosecution, etc., would follow under the law. Then, friends, most importantly, the law says there is no U-turn because of section 6(1). Once Benami transaction is done and Benami property is acquired, its retransfer is not allowed under the law. Thus, its correction or reversal is not envisaged under the old or new law. There is no scope of confession or surrender or settlement or compounding, etc. Thus, legal consequences of entering into Benami transactions are imminent. Confiscation of Benami property and prosecution of the offender. This is something where very, very harsh consequence is being felt beyond tolerance. Why I'm saying beyond tolerance? Because since, this law all along allowed any kind of transaction. Indian Trust Act 1882 allowed Benami transactions. Our own Indian Income Tax Act section 281A allowed Benami transactions to be done. So if it is now, being applied from retrospective effect, then at least the chance should be given to correct this transaction if for no fault some property is lying not in the name of real owner but in the name of somebody else. So the chance of correction should be given before taking harsh actions. That is what I would, in my personal opinion, like to suggest to our respected authorities, whosoever has the power to make legislation or make amendments thereof. Multiplier effect. The provisions of Benami law are in addition to provisions contained in any other law. These are not designed to be mutually exclusive. Thus, in any given situation, any one or more, all these laws such as Income Tax Law, PMLA, Black Money Act, Companies Act, FERA, as well as Benami law, can be invoked simultaneously if violation has taken place or offense has been committed in respective laws. It is quite possible. I will give you some practical situations where one transaction leads to violation, might lead to violation under different laws. Then there is no compensation for any damage. There is no provision for payment of any compensation to the person whose property is confiscated under PPPT Act. Similarly, no damage can be claimed for vacation of any wrongful attachment. Suppose an attachment was made, which was wrongfully made, the person suffered. The law says, no, you cannot claim any damage. Even if it is proved that the attachment was wrongful since inception. That is very strange. You are making a specific provision to deny the benefit of any damage also. Even if the wrong things are done, okay, if wrong thing is done on the part of the citizen, he has to suffer. But if some wrong thing has been done, which is apparently wrong, no logic. Let the courts decide what should happen. And if provision is being made, no, you will not. This is creating imbalance in the society. Then this will not deter somebody from doing even the wrong actions, taking the wrong illegal actions against the citizens. I do not know why this specific provision was needed. Let it be left open to the court in their court's wisdom. So, if this, it is just giving a flavor as if we are no more very much interested in a civilized society. We are now interested in a society where people do not feel the flavor of democracy. Is that so? I mean, this is a question coming to my mind, and all of you are wise enough to answer it properly. Variety of other issues arising under new Benami law. So friends, I am not saying that the wrongdoer should not be punished, but I am saying that there has to be always a constant attempt to ensure that right and wrongs are distinguished at any given point of time. Variety of other issues arising under new Benami law. Is Benami law applicable to property situated outside India? Very good question. In fact, he is being asked repeatedly. Mr. Jaitley replied this answer very clearly that for this property situated outside India, we have brought out Black Money Act. And for dealing with the properties in India, we have Benami law. But there is one catch. Even under Black Money Act, there is one section, section 14, which is a kind of Benami law within Black Money law. Now, why I am saying so? Because there also it has been held that if the property is held outside India in some other name, then the beneficiary and beneficiary can be assessed, etc. Number one. Number two, though properties located outside India are not covered under Benami law, but if an international transaction has been done and which culminates into holding of the property situated in India, whether movable or immovable like shares also in any Indian company, held abroad, held by an NRI, non-resident, foreign national, if it is Benami, it can be hit. Now, what if jewelry purchased 10 to 20 years back and the person in possession is not having the receipt of the jewelry? Can that be roped into Benami transaction? Now, very good question, because there is one clause, that is clause C, clause D, which might hit such transactions. But believe me, the intention of the law is not to hit such transactions. Its improper implementation can lead to hitting such transactions. If I have purchased the jewelry, if I say I have paid the consideration, whether the source is proved or not, it is not Benami. Because if source is not proved, there is another law, that is section 68 and 69 of Income Tax Act, which can take care of. Only when I say I do not know who has paid the consideration, at least I have not paid the consideration, then only the burden will be there upon me to identify the person who has paid the consideration and produce him. In that case, if I do not produce or identify him, then it in clause G can be invoked and it can be hit under Benami law. But only condition is only wherein I am saying I have not paid the consideration, somebody else has paid the consideration. If anyone purchases land through NRI salary and paid money through NRI account paycheck and registered the land on wife's name, will this land be considered as Benami property? Suppose land has been purchased using NRI salary. Now, this is something which is coming from abroad. There is no problem in that. The only thing is that the land which is purchased should be purchased only one who is entitled to purchase the land. NRI is not entitled to purchase the land, but exemption is being given to wife because he can buy in the name of his wife. So because of this reason, Benami law will not be applicable, and sources are also known. But the only difficulty is you kindly check under FEMA on this aspect also, because non-residents are not allowed to buy some agricultural land, etc. here. So keeping in view that fact, this needs to be taken care. The law is to be complied in true spirit. Now the time has come then that you cannot just show the compliance of the law. You have to comply the law, and actually you should do the business in such a manner the law is complied. Now, if Mr. A is from Punjab but wants to do business in Himachal, where he cannot buy property, so he buys property in the name of his cousin who is Himachali and sets up a hotel and starts reaping benefits. It is a classic case of Benami. If the cousin has no interest in the ownership, if cousin is a partner, if cousin also enjoys the benefit of the ownership, if it is a venture between the two, it may not be Benami. But if he is a known entity, it is a classic case of Benami. Then this slide I have already answered. I can go to the next one. Now, yes, I will be taking up PMLA. before I take a PMLA, I would be taking a few questions which have been asked so far. Mr. Atul Puri is saying whether the law is made, the requirement and purpose of it are detailed. Has the same been done for this law? In fact, Puri Sahab, this is a very good question. Earlier, the law used to be referred to select committee and there used to be deliberations. Here, just reverse of it happened. First of all, it was brought in quite hurry, as I am told from the reliable sources. I mean, only one night was given to the law ministry to vet it and send it. Rather, on the other side, the one report is available on the public domain, a report given by the Standing Committee of Parliament under the chairmanship of Mr. Veerappa Moily. This bill was referred, before this became act, there was a bill prior to coming into existence of the present dispensation. The earlier dispensation had referred the matter to the select committee. And Mr. Veerappa Moily in his report, it's a 200 pages report, mentions that if this law is brought out as it is, it will create chaos in the country. So it should be drastically amended. Now it was not amended, it has been brought out as it is. You can verify the provisions earlier in the bill and the provisions thereafter. Apart from small tweaking, and you can kindly go through the report. So whosoever is agreed with my suggestions may kindly go through the report first. Another trend has been noticed that if a person is investigation and one dealing with him, irrespective of the quantum, is brought under investigation, is actually required to be justified. Yes, concept of materiality should be brought out. Shri S. Prabhakar has raised a question. With due respect to the speaker, the learned speaker is giving an impression that businessmen, by doing business to make profits, are doing great favor and they should be given all immunities from all offenses that they may commit while doing their business. Probably, Prabhakar sir, you have not heard me fully. What I am saying that you should not presume a person to be culprit. Did I say he should be given clean chit? I am saying repeatedly, wrongdoer should be punished. There is a greater need to check the leakages in the economy. But in the same manner, when we do chemotherapy of a person, we do in such manner that the person is not killed ultimately. You are hitting his bad cells, then good cells are not completely washed off. So it is a very, very thin line that you have to walk through. You have to use it as a surgical instrument, not as a sword. If the entire enthusiasm to do business is killed, who will bring wealth to this country, sir? This is what I am respectfully saying. I'm not saying anything else. You did not respond to this question, that when the appellate tribunal is not working, how can you allow the enforcement agencies to work? That too for 2 years, sir. Sir, will it be justified, sir? Sir, the people's property has been attacked. It is not possible that the 100% actions of the investigating agencies will be absolutely fair and legal. Not possible, because they are working under some pressure, some agendas, etc., etc. So who will look after them, sir? Will it be all right that the tribunal is stopped from working and the enforcement agencies are kept working, sir? Sir, you see in your life also, wherever the remedial mechanism is not available, but the action taking mechanism is available. So what kind of life it will be, sir? Then Mr. B.K. Subramaniam is saying, so I am just at the thought, at the cost of repetition, I am saying that we need these laws. These laws only can help us survive in the long run. Otherwise, country will be chaotic and it will be full of offenders. But it's wise, but is extreme on the other side is also true. If we misapply the laws, then in the short run itself, country will go to the dogs, because people will run away from here. So you have to avoid both the extremes. You have to choose the middle path, the fair path, the right path. B.K. Subramaniam ji is asking whether a benamidar can claim possession of the property by virtue of property registered in his or her name. Now, he can claim possession once the government is ready to leave the property. If the government itself is going to confiscate it now, he cannot. And rightfully, this law has been brought out. People cannot just continue to hold Benami property and claim as their right. It will create imbalance in the society. Only thing I am saying is that law should be applied rationally now. Cannot be applied retrospectively with such a degree. Because earlier, there were customary practices. Kindly read this report of Veerappa Moily. There were customary practices. Indian Trust Act, Section 81, 82, and 94 allow Benami transaction. Section 281A of Indian Income Tax Act 1961 allowed Benami transactions. 1988 Act of PBPT remained in the inactive mode. So suddenly you cannot be that harsh. That is what I am respectfully saying. What is money laundering? Somebody said converting black into white is money laundering, but that is akin to tax evasion. So something more is required to make it money laundering. So symbolically speaking, in terms of colors, conversion of red into white might be money laundering, where the red would denote crime, would denote blood, in turn crime, and so anything from crime to known crime will be money laundering. So meaning thereby any crime is done, proceeds are earned therefrom, and those proceeds are portrayed as if they are legit, not earned from commission of crime, is money laundering. Simple. So legally speaking, the definition under money laundering is something like this. The PMLA defines offense of money laundering under section 3. Whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the pursuits of crime, including its concealment, possession, acquisition or use, and projecting or claiming as untainted property, shall be guilty of offense of money laundering. Now this word "and" I have put in red color because according to me this is a necessary condition. Unless the projection is done from illegal to legal, I would not say offense of money laundering has taken place, but some amendment has been made in the law in August 2019 by way of bringing out an explanation to section 3. And some people are interpreting that explanation is now removing this word and even if any one of these things are done, it will be money laundering. It is not necessary to project his property as untainted. So merely a crime is done and proceeds are earned, it is money laundering. With due respect, that is not the scheme of the act is. So probably we need to think it properly. Otherwise, harsh consequences will happen. So for money laundering, unless a person portrays bad money as good money, he cannot be said to be an offender under the money laundering law. Then proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or the value of any such property. So a person does a crime, earns income therefrom or money therefrom or any asset therefrom, that is proceeds of crime. Now scheduled offense means all those offenses which are mentioned in the schedule appended to the PMLA, and the list is very, very vast. Like all environmental laws are covered, many offenses covered under IPC are covered, such as forgery, fraud, dacoity, theft, offenses under Prevention of Corruption Act, under treason, under National Security Act, under other criminal laws, some violations of Black Money Act, some violation under Customs Act, etc., etc. Violation under the income tax law has not been mentioned there, so it is not one of the scheduled offenses. So as I explained to you, the concept of money laundering, it involves 3 stages. Stage 1, commission of the scheduled offense. Stage 2, generation of proceeds of crime. And stage 3, commission of money laundering by placement, layering and integration. According to me, all these 3 stages must be achieved, only then it can amount to offense of money laundering and not before that. Web of actions. Now you must be wondering that why and how this law has become so harsh in the country. Why any brush with ED is not a smooth experience, whether a person has done something wrong or has not done something wrong. In both the situations, if he has done something wrong, then of course. And it is because of these reasons which I mentioned on this slide that many actions start simultaneously. For example, first of all, the investigation agency who is investigating the main offense, scheduled offense, will start its action. Then investigation by enforcement directorate will be picked up on the basis of such FIR or complaint, etc. And it will take actions into 2 directions. First of all, it will make the attachment of the properties alleged to be proceeds of crime. Then it will also file a complaint to the court, and then complaint will reach to the same court where the scheduled offense is happening. So both the trial for the prosecution will happen simultaneously, and also the attachment of properties, and then multiple actions arising therefrom, one after the other. Then this slide I have made just to explain a small concept, how that one transaction into multiple actions from various agencies if he has done something wrong, and that one transaction will not invite many actions if he has not done something wrong, have done the things rightly. So suppose a person did some import and distribution, its distribution in the country. Now it is alleged to be smuggling, and suppose he files an income tax return, and suppose he earned a sum of rupees 10 crores as income therefrom. He, in his income tax return, he says yes, he has earned income from smuggling, and discloses a sum of rupees 10 crores as income. Then let us see, he shall be hit under what laws? So first of all, under Black Money Act, no, he will not be hit. Under Income Tax Act, no, because he has disclosed full amount 10 crores. Under PBPT Act, no. Under PMLA, now since he is calling a smuggling as smuggling, he is not converting his untainted into tainted. He is treating as he's tainted into untainted. He's treating as tainted only. No. FEMA, yes, would be possible. Now let us evaluate the situation if the facts are changes little bit in this manner as I am submitting, that out of rupees there's 10 crores, he in his income tax returns declares a sum of rupees 10 crores as income from trading. Instead of calling it as income from smuggling, he says it is income from trading. So this is just a very broad example which I am giving to explain the conceptual framework. So out of rupees is 10 crore, he discloses in income tax return as rupees 2 crores as income from trading. Remaining out of rupees, remaining 8 crores, rupees 3 crores is sent abroad to be deposited in his bank account, which is not a disclosed bank account. And then remaining 5 crores, he gives the cash to one company, namely B Limited, says his name is Mr. R. And the B Limited gives the money back in the form of a check as share subscription amount to his company R Limited. And R Limited in return of that issues shares to B Limited, and B Limited becomes the shareholder whose real owner is Mr. R, the real owner of those shares. So what are the possible implications? Let us evaluate one by one. Under Income Tax Act, yes, because he has suppressed 8 crore rupees income. Under Black Money Act, yes, because he has stashed the money abroad in his bank account, which is not a disclosed bank account. So under Black Money Act, he is liable to pay amount, penalty and taxes on that rupees 3 crores. Then under PBPT Act, yes, because the Mr. B Limited has become Benami Law of the shares which B Limited is holding, real owner is R, and B Limited is a Benami shareholder. Under Companies Act, yes, because he will be committing some violation under Companies Act because of fraud and all that. So SFIU also come into picture. FEMA, of course. So, and if it is a listed company, then actions by SEBI are also possible. So, I mean, this example I said that how multiple actions can be brought out, because one offense, one transaction may involve different steps, different sub transactions which may involve implications under various laws. So this case study I have brought out to portray a picture to answer that question, that how, why and how businessmen should be spared. So this slide I have brought out, this case study should be brought out, that where I will be asking question from you that, sir, in this case, do you think the businessman should be hit so hard, even if he has done some mistakes, and when the punishment should be proportionate to the mistake, or the punishment should be disproportionate? Because our constitution is also based on the doctrine, well-established doctrine of proportionality, which has probably been lost somewhere. So one distillery unit was established in Rajasthan, somewhere in Rajasthan, and it was employing around 500 persons. And sometime back, way back in 2009, some violation took place under Water Pollution Act and Environment Protection Act because of improper functioning of water treatment plant, and Pollution Control Board filed an FIR. Now, subsequent to that, some corrections were done. The functioning of the water treatment plant was restored properly, and thereafter Pollution Control Board did not pursue the matter because everything was all right. They checked it, examined it. But in the meanwhile, ED swung into action few years thereafter and sends a notice for attachment of the factory building. I was again, when I received this brief, I was again very puzzled that how can ED come into action because of this? Where is the proceeds of crime and all that? How can factory attachment be done on this ground? So the logic given therein was that since the water treatment was not functioning properly and the discharge of water was beyond the license capacity into the river. So say the license capacity was 50 KL and the discharge into river was say 75 KL. So this extra discharge of water was led to extra production. That extra production was not legal. Since extra production was not legal, extra sales arising because of extra production was also not legal, and extra profit arising from such sale was also not legal, and extra profit must have been invested in the factory building. So factory building becomes a proceeds of crime. So therefore, we are here to attach the factory. So when we filed the matter, wisdom prevailed, and Honorable Justice Manmohan Singh passed an order granting status quo from attachment or confiscation of such kind of in such kind of cases. But thereafter, we thought it is end of the matter. Few years thereafter, now ED has filed complaint, and the gentleman is not being granted bail even without even hearing the bail matter on merits, because the trial court in its wisdom has issued warrant instead of issued summon, despite the fact that the gentleman, the directors of the companies have extended full cooperation to the investigation, and the investigation agency has never thought it necessary to make any arrest. But because of this issuance of warrant, now the person is on the verge of arrest and he is now seeking the legal remedies, running here and there. So, now you kindly see action under Water Pollution Control Act, which nothing is being done by PCB because everything has been restored properly. Now ED comes into action. So can you see the proportion? Now, under such circumstances, whether all right, you make a trial of him, let him undergo the process, but whether arrest is necessary, that too after now 10 years from 2009, and more than 10 years. What for? So is it not something highly disproportionate? This is a question coming to my mind. If you feel all right, the concept of proportionality will be lost, then chaos will happen. Then another case which I wanted to put forth is now that of a default in the case of bank. Many people have done defaults in repayment of their loans, but there have been two broad reasons for such defaults. First reason is that people have done siphoning of their funds. They have cheated the banks. They have made improper end use, which was not permissible. One reason. Second category of reasons are those where people have been hit because of their bad manner of doing business, or because of cyclical corrections, collapse of industry, and business is the name of success and failure, profit and losses. So genuine business errors might also take place. Business judgment may also collapse. So anything might have been done. Now, these cases of bank default cases are widely prevalent in all the offices of the ED working in the country, because banks, to make recovery of their dues, would file FIR with CBI or EOW. Now, this kind of FIR is eligible, and the offenses mentioned therein are most of the times scheduled offenses, because section 420 and 120B all are invoked of IPC. So ED will pick up those FIR, register the case with them as ECIR, and start taking action. Now imagine a situation. Actions are being taken. Now it is not yet proved whether the siphoning of funds has taken place or it is a genuine loss of business, genuine collapse of business, bona fide, beyond control of the businessman. There could be other reasons. But now ED is on its spree to make attachment of the property. Now what property? Or proceeds of crime. What proceeds of crime? So suppose a large corporate borrower has taken 1,000 crore rupees loan. So wherever this 1,000 crore has been utilized, it may be utilized with the unconnected person. The trail is being made and those persons are being found, or their properties are being attached without yet there being finding that what it is. So I am not saying action should not be taken, must be taken. but there has to be some fair approach, because not only that, their properties are being attached, their complaints are being filed, and they are being arrested by the ED. Even if CBI has not arrested, but ED is arresting them. So some kind of middle path has to be adopted, so that the agencies could also work to nab the offenders, also for the reason that that innocent people are not hit. So there has to be some mechanism which should bring out some kind of fairness in the working mechanism, so that at least innocent are not are punished. Next slide. Yes. So fundamental questions which arises here is, what is money laundering? Is it different from tax evasion? Whether tax evasion is also money laundering? So I have answered first two questions. Now, whether tax evasion will also be money laundering or not is a important question, which will depend upon the facts of the case. Tax evasion ipso facto is not money laundering, but there may be some associated actions while being done while doing tax evasion that may take part of the scheduled offense. Then it can be treated as money laundering. What are the authorities governing money laundering laws? As you know, Enforcement Directorate, Adjudicated Authority, Appellate Tribunal, they are the authorities, and then High Court and Supreme Court, of course, are there. What is the punishment or offense of money laundering? So first of all, the property is liable to be attached. Then, the persons who are involved in the offense of money laundering can be punished as by way of imprisonment for 7 years to 10 years. Then what are the consequences of provision of PMLA removed by Enforcement Directorate? I have already shared. What are the broad powers vested? Yeah, powers of ED are also quite wider than the Income Tax Department. So power of making of attachment properties, one power. Power of making search and seizure and also arrest of the persons, and also recording of statement under Section 50 are the broadly 4 or 5 powers granted to the ED. What kind of properties are attached? As I said, it is the proceeds of crime which can be attached, but any property other than proceeds of crime can be attached. Now, this is the question which entire country is asking. 2 high courts have already answered these questions. That is Honorable Punjab and High Court in the case of Seemagar, Andhra Pradesh High Court in the case of Satyam Computers and Kumar Pappu, and Ali Balshar of Delhi High Court also, which say ki no, that properties only which are directly associated with proceeds of crime can be attached, not any other property. So Section 2(1)(u) should be interpreted in this manner only. So suppose the allegation is that the house property, which is, suppose a person did some theft and he earned some money, the money he lost. So first of all, let me take an example. So money is invested in gold, gold is there, it can be attached. Now, whether gold is not of sufficient value, he has spent some money, whether any other property can be attached. The law does not permit it. And that is how what has been held by the courts also. And there is a rationale behind it. We can discuss it any point of time when we'll have a detailed deliberation under PMLA. But both the judgments are being ignored. And in most of the cases, other properties are also being attached. So when I saying that rationality should prevail, I mean to say this only, that since these are draconian law, so the investigation and the action should be done with a fully fair and legally permissible approach only. The enforcement agencies should not create their own laws, because it will otherwise have an overreach and overkill, which is not the purpose. What are the legal remedies? Now somebody is saying, suppose we need to do investigation. Yes, we need to do investigation, but the process of investigation, if becomes such that it is as good as the final punishment, irreversible damage during the investigation itself, that is not the power. That is not the objective. Then this country will become Jungle Raj kind of country. No, please stop it. Who stops you from verification? But you should have the mindset of only verification. If you have mindset of giving the final punishment at the verification stage only, then the right and wrong will be mixed up. So what are the precautions to be taken to avoid entering into money laundering laws is the question which is arising in our mind now. As I said to begin with, we have to take care of the mistakes of other people. And I was also saying now we have to do our business and live our life in this manner, that not only that we have to do the right things and rightly follow the law, but we should do the things and the transaction in such manner that if we are required to prove that you have complied with the law, then we have requisite information and documents and evidences to prove that. So that is the time in which we are passing through. What is the status of bona fide purchaser? Now, again, this is a very interesting question, because I mean, very strangely speaking, I mean, there is no specific provision to take care of bona fide purchaser. But that does not mean that the law gives the power to make attachment of the bona fide purchaser. Because of improper understanding of the concept of pursuits of crime on the part of certain implementation agencies, this problem is arising in the country. The pursuits of crime is a dynamic concept, not a static concept. That is what we need to understand. Meaning thereby, suppose I have something which is derived out of pursuits of crime. Now, if I sell it to somebody, I in return get money therefrom. So now the pursuits of crime or the property involved in money laundering is not akin to a contraband item, which is intrinsically a prohibited item, say drugs, say weapons, etc. So a contraband item is a contraband item always in whosoever hands it is. It is to be prohibited and confiscated for sure. But money is not of that nature, or property derived from that money is not of that nature, because it will be pursuits of crime based upon the intention of the user. So something can be pursuits of crime in my hand, a property may be pursuits of crime in my hand, but if it reaches in the name of other person who has acquired it bona fide, it ceases to be pursuits of crime. Because pursuits of crime is replaced by the money which he has paid me now. That becomes liable for attachment in the hands of the enforcement director. Hawala transactions, of course. Why not? I'm skipping some of the things. Can defaults in bank loans obtained through fraud can be covered under the money laundering or any other law? As I said, if the bank loan has been obtained through fraud, then violation has already taken place. The commission of crime has already taken place. 120B, 420 of IPC are affected. Then the whatever amount has been derived, that can be treated as pursuits of crime. Now, with this Black Money Act, 2-3 sentences therefrom, I will bring an end to my deliberations for the time being, and then we can have another session if required on question answer or anything which is left. Now, with regard to Black Money Act, only 2 things are required to be kept into account. A, if any foreign income is being earned from any source from foreign countries, that is required to be disclosed in the income tax return. If any foreign asset is held, earned from Indian sources or foreign sources, by resident, any of these 3 things, by residents who is required to file return in country, or even if he is not required to file the income tax return in the country, but if he is resident, then he should disclose the same in his income tax return. Then there will not be any implication under the Black Money Law. Otherwise, the foreign income as well as the value of that foreign asset becomes liable for assessment under section 10(1) of BMA, equivalent to 30% tax payable and 60% penalty plus prosecution separate. So thank you very much, my dear friends. I will now take up some of the question answers which have been put before me in the question answer session, in this question answer box. Now Subramaniam ji is asking, now first of all, Mr. Sirish Narsoma is asking, this is
Ashwini sir.
Yes, sir.
Just request Amit Khemka ji to say something because he was telling. So let him just say, then we'll take a question answer.
No, I'm saying that 2-3 questions from question answer box we finish, so that I bring my deliberation to an end, then Khemka sir can join one flow. So whether registration, whether when NRI purchase property in the name of his father, mother, brother, is it Benami? Sir, unless there is a joint ownership, it will be Benami. So the gentleman has to, if he is also claiming himself to be the owner, then he has to be joint owner. Otherwise, he can gift it, forget it. Then Mr. Subramaniam is asking whether Registration Act mandates both purchaser and seller personally present and sign before SRO. How a purchaser can claim ignorance? Yes, very good questions you are asking, and these are the questions which are rising in our mind. So, I mean, these are the questions of factual evidences which has to be brought out. Very good question you are asking. So, I mean, it cannot be easily said to be Benami. He cannot place ignorance, and that is what I and Khemka sir have been deliberating number of times. Mr. K. Handu Saab is asking how to find a wrongdoer unless verified. Yes, sir. Of course, you verify, but from the intent of verification, not from the intent of punishment. Verification has to be as detailed as possible, but should not cause an irreparable damage to his property or his reputation. And Dom Daniel Saab is asking if very fair and honest talk. Keep it up. Thank you, Daniel Saab. Whatever is coming from my heart, I do not know whether right or wrong, whatever I am feeling, the pain in the people, I am trying to reconcile the need of the government and need of the business. Both have to be reconciled. You cannot ignore the either of them. CA Ajay Gupta is saying immovable property for further release, development, purchased by new company, but the amount paid by the directors from their accounts who resigned later from the company but still available and doing other business, can the same be taken as Benami? Ajay Saab, I mean, the more facts are required to be understood before we could answer this question. And what I am trying to say to sum it up is, let me stop sharing it. What I am saying to sum it up is that the time has come when we should pursue our life and our business in a manner that we should not only show that the law is complied, we have to make substantive and full compliance of the law. Otherwise, we will be hit one way or the other. Thank you very much. Now, Khemka sir would definitely have something very, very useful to be added.
Okay, thank you, Ashwini ji. Khemka ji, can you just give your thoughts? I think Amit ji may be joining. In the meantime, Das sir, you are there?
Yes, tell me, but
Das sir, I just want to understand, the Ashwini has shown the example of environmental law. The environmental law is a ED matter, sir. How this is a schedule offense, why this has put in the schedule offense. Second, you can give both the answer. SEBI has a prescribed formation, prescribed law, and they have prescribed that this penalty, this violation, you have to pay this penalty, this violation, you have to pay this penalty, and then there is a prosecution also under Section 24 of SEBI Act. Now everything is given there. What is the concern that you are connecting that technical violation of SEBI and environmental violation in the money laundering case?
see, this case, since I was associated with that particular case Suniji was mentioning about, it is the law as the lawmakers did it originally, and that is exactly what I was dwelling upon. Initially, it was meant that proceeds of a crime from serious crimes like drugs, like human trafficking, there are certain things for which it was meant. And we have, in our anxiety to have a wider net, have a control over larger population in this, under that net, we have increased the number of scheduled crimes, even for which separate remedies, separate laws are existing. He is being proceeded under environment law for last 15-20 years and no action is being taken because they know that it is a trivial violation. And maximum he would have been given some penalty, some 50,000 rupees or maybe something like that. at the most. But the administratively, after inspections, after 7 months, he has remedied his defect. The administration was certified and he was given this thing. And mind you, the extra profits he made, he paid tax on it, he paid excise duty on it, and he has not hidden anything. He could have done everything hidden so that you could not have caught him. So what I am saying, this is, first, you are saying that ED is hard pressed to work, it has less money, less manpower, resources, and this is, but who is asking you to take extra load? Number one. Number two, these kind of offenses were not meant. Why those are being taken, and these are the classic cases where businesses getting unnecessarily harassed. That is the kind of thing. And other laws are existing, competent, and it is giving rise to multiplicity of proceedings under multiple laws. The predicate offense is being taken care of, and it is considered not too serious. And the money laundering, he is now he has gone up to Supreme Court now for avoiding arrest. So you can imagine this kind of situation. And yes, SEBI has its law. You see, SEBI, Insurance Regulatory Authority, RBI, and classic case of PMLA is more than 65% of cases come from bank frauds. Bank frauds means loans taken, gone sour. So then it could be business failure. It could be like Vijay Malaya case. It could be real fraud. It may not be fraud. But the banks, they allege fraud so that their complicity in the matter, their own personal complicity in the matter should not come to the fore. But in any case, that is a matter for CBI to investigate and CBI to prosecute, and they should be get done with that. And because that has been included in scheduled offense, now those are become handpicked case, because it is like sitting dog, because the properties are always there and they can attach the loan amount plus interest accumulated becomes the proceeds of a crime. If no property is available, even the ancestral property of these people can be attached. And even if they have sold some property to some other people, even they are attaching that. So it is creating multiplicity of proceedings, multiplicity of writs. And I think now professionals will survive on these cases only. It is unnecessary. Courts are clogged. So my point is that ED should concentrate on serious crime of money laundering as it was mandated to do originally. And it should not be, they should not stretch themselves thin so that they would be not attending to their original mandate very well, and will show their proficiency, competence only by doing these sitting dog cases. Thank you.
Very nicely covered, sir. My another question is, are you back? Okay. Sir, another point is, Ashwini-ji, knowingly and unknowingly. Now this is every law has everything has two things, plus minus, positive, negative, day and night. Okay. But whenever a constitutional law, Article 14, we have designed, there was an issue that this law cannot be plus minus. This should be reasonable. Now here you have covered the entire thing, day and night, plus minus, universe and the earth. So where is knowingly and unknowingly, both the things are covered. How will you say if somebody is coming to you as an advocate and doing something wrong, will you be responsible because you are unknowingly doing this?
No, that is what I mentioned. In fact, we have to create the laws in such a fashion that the persons who intended to do the things wrongly, they should be hit hard. But during the carrying of the business, if the mechanism or structuring is such that it happens and you fall part of some circle where you did not intend to do wrong, there should be some mechanism to make settlement and to make U-turn and to come out of the litigation. Nobody is going to gain if constantly a businessman or other people are being dragged into litigation and the courts are choked. Once the courts are choked, then what will happen eventually? The real wrongdoers will also stand to gain, because the courts will not have time to make conviction for them. And probably that is why the statistics will speak louder than anything else. That the ED itself mentioned that, sir, our conviction rate is very low. So not even 1%. So they were saying from the saying, sir, देखिए हमारा law कहाँ draconian है? Conviction तो इतना low है. That is where the draconian things come into picture. कि आप देखिए आपने 100 केसेस लेके गए, आपने कन्विक्शन एक कोई कर पाए, इसका मतलब 99 केसेस को आपने उस प्रोसेस से निकाल दिया जहां पर डैमेज तो इरिपेरेबल हो गई, लेकिन वो केस तो था ही नहीं इस लायक. दैट इज व्हाट आई एम सेइंग कि आपने इरिपेरेबल डैमेज तो कॉज कर दी, 99 केसेस को कैसे जस्टिफाई करोगे आप कि क्यों लेके गए आप वहां तक? दैट अंडरगोइंग द प्रोसेस इटसेल्फ इज derailing the path of a successful businessman. So
Okay.
that is why I am saying that there's some mechanism and checks and balances have to be brought out.
Okay, Das sir,
Ji.
was interplay of so many laws intended by the legislature, or it just so happened?
I think how can honestly one reply to this? It could have happened just like that, but legislature in its wisdom has created all these laws. So the thing is that it is for legislature to determine. But what I say that it has not happened unknowingly, because they have the assistance of the executive, they have the assistance of a law ministry, they have the assistance of their select committees and standing committees. So they, with all these facilities, whatever has done, this interplay and multiplicity of proceedings, it is probably, I would say, intended. And it has its own dangerous effect. You see, there is no really, for same offense of a bank fraud, a person will have to face 3 different litigations. You see, for same offense, if a prevention of a corruption act is more than adequate to handle it, he has to also face the money laundering offense, where the punishment is swift, because his properties will be attached and he will be deprived of what Suriji told, the irreparable damage is caused. And even if after 20 years, he will get himself scot-free and he will not be convicted, by that time he is finished. So far, ये 2005 का लॉ है, आज तक 20 आदमी को कन्विक्शन नहीं हुआ. मेरे ख्याल में 19 people have been convicted. Out of that, 5 people from one family in Jharkhand. So basically, it is in one case. So that is basically 13 and 5, 18 or 19 people have been convicted so far in all these years. That goes in to show the efficiency of the enforcement agency that is implementing this law. So, and on a mere suspicion, the ECIR is being written because the independent investigation is lacking. And whether independent investigation is taking place or not, nobody is there to oversee. These are the certain flaws in this law. So that is exactly, that is bothering. In fact, that is why the matter is being agitated before the highest judicial authority, Supreme Court. And let us hope something will come out of it. But I wish the executive, the government should have taken note of it and tried to bring in some legislative intervention to really redress the difficult provisions whereby people have no remedy and they are suffering because of the arbitrary action of the executive.
Okay, okay. So, sir, now time is over, and we have given a very interesting point, and Ashwini has given answer of all. There are some few questions are still coming. So, what we will do, these answer we will send it to you, Ashwini sir. I'll pass on to you so you can reply to them. With this, thank you very much. But as a customary, what we are doing, we are asking 1 minute your concluding comments, the message which you want to give it to the anybody, regulator, company, wrongdoer, and the non-wrongdoer. So I will start with Ashwini, then I'll request Das sir to close this.
मैं मानता हूँ cost of compliance, non-compliance has become too high now. Earlier, the cost of compliance was low, cost of non-compliance was low and compliance was high. Now the cost of non-compliance has become too high and cost of compliance is low. So therefore, it is better to make compliance, because non-compliance has become unbearable because of various interplays and multiple implications of law. And it is not even feasible to live, breathe properly and do business, but to say of doing business. So therefore, let us do the transactions at arm's length, keeping in view the all possible elements of purity into the transaction and examining it, getting it evaluated through the prism of these laws, so that we can focus on the doing of business and assist also the government in cleaning the economy.
Okay.
So that is how I think it will be a win-win situation for all. Thank you very much.
Das sir, your comment, sir.
Thank you. Since we are all professionals here, I'll say a little differently. Over the last decades, the world has witnessed increasingly sophisticated financial crimes. It is very complex. Opaque arrangements are taking place. Often cross-border arrangements are taking place. And these crimes are facilitated by a small subset of professionals, which includes lawyers, chartered accountants, financial advisors, with whose help the criminals are able to engineer these complex arrangements. My request is that none of us should ever assist any such activity. These crimes can have hugely damaging impacts on society, on countries, not only ours, other countries also, and families. So the best is to avoid doing. And as I said, a very small subset people are so specializing in this. So the best is not to keep oneself away from these activities. That is my message.
Okay. Amitji, you are there? I think Amitji's connection.
Network issue seems to be there.
Okay. So friends, thank you very much, Dr. Das, Ashwini Bhai and Amit Bhai. You have done excellent. We have a very excellent deliberation where you have given the depth of this particular issue. And in next program, we will try to call the regulator also. So whatever we are saying, it is between two person. But if we have a regulator, he can understand the pain of the industry also, and the professional point of view from our side, it will be a better. But what we will do, we will try to write to the regulator the points and the views of the public which we have received. Maybe something can change. So thank you very much, all the participants. Thank you very much, all my learned speakers. And friends, our journey will continue. As you are aware, this was our 79th webinar. Now 80th webinar is on 11th, and that we are doing on ESOP. Now, the very interestingly, if you see the labor law, labor code is coming from 1st April, and the cost of manpower will increase drastically for all corporates. So there is a one model that is that you include in your package the ESOP, which is one win-win situation for the employee, win-win situation for the company, and win-win situation for the performance basis. We will organize a program on ESOP, taking care of how the labor code can impact this and how this can impact the labor code, and how the ESOP is a popular mode, not only for the listed startup, but for all companies, including unlisted companies. And there are so many mechanisms now that how to repay this ESOP by buyback or purchasing these shares. We will discuss all these points in the next webinar on 11th. Till the time, thank you very much. Thank you very much.